Minors Counsel, an introduction, relevant code sections, and case law. California Family Code Sections 7861 and 3150A, appointment of private counsel for minor. Family Code Section 7861 states, the court shall consider whether the best interest of the child requires the appointment of counsel. If the court finds that the interests of the child would require representation by counsel, the court shall appoint counsel to represent the child, whether or not the child is able to afford counsel. The child shall not be present in court unless the child so requests or the court so orders. Family Code Section 3150A, if the court determines that it would be in the best interest of the minor child, the court may appoint private counsel to represent the interests of the child in a custody or visitation proceeding, provided that the court and counsel comply with the requirements set forth in Rules 5.240, 5.241, and 5.242 of the California Rules of Court. We will now discuss the California Rules of Court 5.240. In that section, it discusses appointment considerations, requests for appointment of counsel, orders appointing counsel for a child, panel of counsel eligible for appointment, complaint procedures, and termination of appointment. If you look at that rule, it gives you pretty much a manual as to what needs to be done so you can represent the child effectively. Appointment considerations. In considering appointment counsel for a minor child under Family Code Section 3150, the court should take into account the following factors, including whether, 1, the issues of child custody and visitation are highly contested or protracted, 2, the child is subjected to stress as a result of the dispute that might be alleviated by the intervention of counsel representing the child, 3, counsel representing the child would be likely to provide the court with relevant information not otherwise readily available or likely to be presented. 4, the dispute involves allegations of physical, emotional, or sexual abuse or neglect of the child. It appears that one or both parents are incapable of providing a stable, safe, and secure environment, or if counsel is available for appointment who is knowledgeable about the issues being raised regarding the child in the proceeding. 7, the best interest of the child appears to require independent representation. And 8, if there are 2 or more children, any child would require separate counsel to avoid a conflict of interest. We're now going to discuss the request for appointment of counsel. The court may appoint counsel to represent the best interests of a child in a family law proceeding on the court's own motion or if requested to do so by any of the following. 1, a party. 2, the attorney for a party. 3, the child or any relative of the child. 4, a mediator under Family Code Section 3184. 5, a professional person making a custody recommendation under Family Code Sections 3111 and 3118, or of the Evidence Code 730, or the Code of Civil Procedure Section 2032.01 et sec. 6, a county counsel, district attorney, city attorney, or city prosecutor authorized to prosecute child abuse and neglect or child abduction cases under the state law. Any guardian or guardian ad litem or special advocate. And then the last one, a catch-all, any person who the court deems appropriate. We will now discuss orders appointing counsel for the child. The court must issue written orders when appointing and terminating counsel for a child. The appointment orders must specify the following: the appointed counsel's name, address, and telephone number, the name of the child for whom counsel is appointed, and the child's date of birth. The appointment orders may also include the following information: the child's address, if appropriate, issues to be discussed in the case, tasks related to the case that would benefit from the services of counsel for child, responsibilities and rights of the child's counsel, counsel's rate or amount of compensation, allocation of fees payable by each party or the court, source of funds and a manner of reimbursement for counsel's fees and costs, allocation of payment of counsel's fees to one party subject to reimbursement by the other party, term and amount of any progress or installment payments, and the ability of the court to reserve jurisdiction to retroactively modify the order on fees and payments. Courts may also use an order for counsel, Form FL323, or may supplement that form, the FL323, with any local forms developed under Rule 10.613. It is important to note that there should be a panel of counsel created by the court showing who is eligible for appointment. Each court may create and maintain a list or panel of counsel meeting the minimum qualifications of this rule for appointment. If a list or panel is maintained, a court may appoint counsel not on the list or panel in special circumstances, taking into consideration the following factors, including language, culture, and the special needs of a child in the following areas: child abuse, domestic violence, drug abuse of a parent or the child, mental health issues of a parent or the child, particular medical issues of the child, and any kind of educational issues. If the court maintains a panel of counsel eligible for appointment and the court appoints counsel who is not on the panel, the court then must state the reason for not appointing a panel counsel in writing or on the record. Any lists maintained from which the court might appoint counsel should be reviewed at least annually to ensure that those people listed on the list are still eligible. Courts should ask counsel annually to update their information and to notify the court if any changes would make them unable to be appointed. Next, we will discuss complaint procedures. By January 1, 2010, each court must develop local rules of court in accordance with Rule 10.613 that provides for the acceptance and response to complaints about the performance of the court-appointed counsel for a child. Regarding Riverside County, our complaint procedures can be found under our local rules. And finally, termination of appointment. On entering an appearance on behalf of a child, counsel must continue to represent the child until one of the following: the conclusion of the proceeding for which counsel was appointed, if they are relieved by the court, substituted by the court with the counsel that is going to replace them, removed on the court's own motion or request of counsel or parties for good cause shown, or the child reaches the age of majority or is emancipated. Next, we will discuss California Rules of Court 5.241. In this section, they will discuss the determination of counsel's compensation, determination of ability to pay, payment to counsel, and parties' inability to pay. Under California Rule of Court 5.241, counsel shall be compensated based upon the determination of counsel's compensation fees. The court must determine the reasonable sum for compensation and expenses for counsel appointed to represent the child in a family law proceeding, and the ability of the parties to pay all or a portion of counsel's compensation and expenses. The court must set compensation for the child's counsel either at the time of appointment, at the time the court determines the party's ability to pay, or within a reasonable time thereafter. An important technique when you file a request for minors counsel, it's always helpful if you at the same time file an income and expense declaration to avoid delay in payment. No later than 30 days after counsel is relieved as an attorney of record, the court may make a recommendation of counsel's compensation and also may redetermine the amount that can be compensated on the court's own motion, at the request of a party or party's counsel, or at the request of counsel of the child. The court is tasked with the responsibility of determining a party's ability to pay. The court must determine the respective financial ability of the parties to pay all or a portion of counsel's compensation before determining the party's ability to pay. The court, however, shall consider factors such as the party's income and assets reasonably available at the time of the determination, and eligibility for or existence of a fee waiver under Government Code Section 68511.3. And the parties must have on file a current income and expense declaration or financial statement. The court should determine the party's ability to pay at the time counsel is appointed, or within 30 days after appointment, or at the subsequent hearing. No later than 30 days after counsel is relieved as attorney of record, the court may redetermine the party's ability to pay on the court's own motion or at the request of counsel or the other parties. Payment to counsel. If the court determines that the parties have the ability to pay all or a portion of the fees, the court must order that the parties pay in any manner the court determines to be reasonable and compatible with the parties' financial ability, including progress or installment payments. The court may use its own funds to pay for counsel for a child and seek reimbursement from the parties. The court also must inform the parties that the failure to pay these fees to the appointed counsel or to the court may result in the attorney or the court initiating legal action against them to collect the money. And parties' inability to pay. Furthermore, if the court finds that the parties are unable to pay all or a portion of the costs of the child's counsel, the court must pay the portion of the parties are unable to pay. The next California Rule of Court that we will discuss is California Rule of Court 5.242. And in this section, the rule discusses the purpose, the general appointment requirements, education and training requirements, annual education and training requirements, applicable education and training, experience requirements, and alternative experience requirements. Under this section, the purpose is stated is, this rule governs counsel appointed to represent the best interest of the child in a custody or visitation proceeding under Family Code Section 3150. The general appointment requirements include to be eligible for appointment as counsel for a child, counsel must 1. Be an active member in good standing with the State Bar of California, 2. Have professional liability insurance or demonstrate to the court that he or she is adequately self-insured, and 3. Meet the education, training, and experience requirements of this rule. The education and training requirements effective January 1, 2009, before appointed as counsel for a child in a family law proceeding, counsel must have completed at least 12 hours of applicable education and training, which must include all of the following subjects. 1. Statutes, rules of court, case law relating to child custody and visitation litigation. 2. Representation of a child in a custody and visitation proceeding. 3. Special issues in representing a child, including the following subjects: various stages of child development, communicating with the child at various developmental ages and stages and presenting the child's view, recognizing, evaluating, and understanding evidence of child abuse and neglect, family violence, and substance abuse, cultural and ethical diversity, and gender-specific issues, the effects of domestic violence and child abuse and neglect on children, and how to work effectively with multidisciplinary experts. The annual education and training requirements include the following. Effective January 1, 2010, to remain eligible for appointment as counsel for a child, counsel must complete during each calendar year a minimum of 8 hours of applicable education and training in the subjects listed in C. Applicable education and training. Education and training that addresses the subjects listed in Section C may be applied toward the requirements of this rule if completed through a professional continuing education group, an educational institution, a professional association, a court-connected group, or a public or private for-profit or not-for-profit group. There is a maximum of 2 hours that may be satisfied by self-study under the supervision of an education provider that provides evidence of completion. Counsel may complete education and training courses that satisfy the requirements of this rule offered by the education providers in 1. By way of video presentations or other delivery means as remote locations, such as courses not self-study within the meaning of this rule. and counsel who serve as an instructor in an education and training course that satisfies these requirements of this rule may receive 1.5 hours of course participation for each hour of course instruction. All other counsel may claim credit for actual time he or she attended the education and training course. The experience requirements regarding appointment of minors counsel include: persons appointed as counsel for a child in a family law proceeding must have represented a party or a child in at least 6 proceedings involving custody within the preceding 5 years as follows. At least 2 of the 6 proceedings must have involved contested child custody and visitation issues in family law, and child custody proceedings in dependency or guardianship cases can count for no more than 3 of the 6 required appointments. Court may develop local rules that impose additional experience requirements for persons appointed as counsel for a child in a family law proceeding. There are alternatives to these experience requirements. Counsel who does not meet the initial experience requirement in letter F may be appointed to represent a child in a family law proceeding if he or she meets one of the following alternative experience requirements. Counsel must, 1, be employed by a legal service organization, a governmental agency, or a private firm that has been approved by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings, and be directly supervised by an attorney in the organization, an agency, or private firm, which meets the initial experience requirements. Or they can be an attorney working in consultation with an attorney approved by the presiding or supervising judge of the local family court as qualified to represent a child in family law proceedings, or demonstrate substantial equivalent experience as determined by local rules or procedure. Rule of Court 5.242 continues to discuss the compliance with appointment requirements. A person appointed as counsel for a child must file a declaration with the court indicating compliance with these requirements of this rule no later than 10 days after being appointed and before beginning work on the case. Counsel may complete the Declaration of Counsel for a Child regarding qualifications, Form FL 322, or other local court forms for this purpose. And also, most importantly, they must notify the court within 5 days of any disciplinary action taken by the state bar, stating the basis of the complaint, result, and notice of any reproval, probation, or suspension. Additionally, this section discusses the rights of counsel for a child. Counsel has rights relating to the representation of a child's best interest under Family Code Sections 3111, 3151, 3151.5, 3153, and Welfare and Institutions Code Section 827, which include all of the following: reasonable access to the child, seeking affirmative relief on behalf of the child, notice to any proceeding in all phases of that proceeding, including a request for examination affecting the child, take any action that is available to a party to the proceeding, including filing their own pleadings, making their own evidentiary objections, and presenting evidence. They may be heard in the proceeding, which may include presenting motions and orders and participating in settlement conferences and trials and seeking writs, appeals, and arbitrations. They have access to a child's medical, dental, mental health, and other health care records and school educational records. They are allowed to inspect juvenile cases, files, subject to the provisions of Welfare and Institution Code Section 827. They have the right to interview school personnel, caretakers, health care providers, mental health professionals, and others who have assessed the child or provided to the child any sort of care. However, the release of this information to counsel does not constitute a waiver of the confidentiality of the reports, files, and any disclosed communications. They have the right to interview mediators, subject to the provisions of Family Code Sections 3177 and 3182. They have the right to receive reasonable advance notice of the right to refuse any physical or psychological examinations or evaluations for purpose of the proceeding that has not been ordered by the court. They have the right to assert any privilege on behalf of the child or waiver of that privilege on behalf of the child. They have the right to seek their own independent psychological or physical examination or evaluation of the child for purposes of the proceeding on approval by the court. They have the right to receive child custody evaluation reports and to not be called as a witness in these proceedings. They also have the right to request the court to authorize release of relevant reports or files concerning the child represented by the counsel or relevant local child protective services. They also have the right to receive reasonable compensation and expenses for representing the child, the amount which will be determined by the court. It's important to note that minors' counsel is charged with the representation of the child's best interest. The role of child counsel is to gather evidence that bears on the best interest of the child and then to present admissible evidence to the court in any manner appropriate for the counsel of a party. If the child so desired, the child counsel must present the child's wishes to the court. Counsel's duties under the circumstances is inappropriate to exercise the duties included above under Family Code Section 3151. They do have the right to interview the child, review the court files and all accessible relevant records available to both parties, and make further investigations on their own that counsel considers necessary to ascertain the facts relevant to the custody or visitation hearings. Counsel must serve notices and pleadings on all parties consistent with the requirement for representing any party. Counsel may introduce and examine their own witnesses, present arguments by the court concerning the child's welfare, and participate further in the proceeding to the degree necessary to represent the child adequately. In any case in which counsel is representing a child who's called to testify in the proceeding, counsel must provide information to the child in an age-appropriate manner about the limitations on confidentiality, and possibly that information provided to the court may be on the record and provided to the parents in the case. They must allow but not require the child to state a preference regarding custody or visitation, and in, again, an age-appropriate manner, provide information about the process which the court will make a decision. Counsel must provide procedures relevant to the child's participation, and if appropriate, provide an orientation to the courtroom where the child will testify. And they will inform the parties and then the court about the child's desire to participate and provide input to the court. There are other considerations. Counsel is not required to assume the responsibilities of a social worker, probation officer, child custody evaluator, or mediator, and is not expected to provide non-legal services to the child. Subject to the terms of the court's order of appointment, counsel for a child may take the following actions to implement his or her statutory duties in representing a child in a family law proceeding. Interview or observe the child as appropriate to the age circumstances of the child, and in doing so, counsel should consider at all times all possible interview or observation environments and select a location that's most conducive to both conducting a meaningful interview of the child and also investigating the issues relevant to the case at that time, in a manner and to the extent consistent with the child's age, level of maturity, and ability to understand, and consistent with the order of appointment for the case. It's also very important for counsel to explain to the child at their very first meeting the counsel's role and nature of the attorney-client relationship, including confidentiality issues. Minors counsel should also advise the child on a continuing basis of possible courses of action and of the risks and benefit of each course of action. It's important for minors counsel to always consider to take positions relevant to the child on legal issues before the court. They must seek and advocate for services for the child. They must prepare for any hearings or trials. They must work diligently to settle contested issues and to define trial issues. They should prepare witnesses, including the child, if the child is to testify. They should introduce and examine witnesses on behalf of the child, cross-examine other witnesses, make appropriate evidentiary objections, always review court files and other pertinent records, prepare motions to advance the child's best interest, including motions to quash subpoenas for the child and other protective orders. They must present arguments to advance the child's best interest, prepare trial briefs and other documents if appropriate, and they must require and request appointment of separate appellate counsel if necessary. It's important for minors' counsel to conduct thorough, continuing, and independent investigations and discovery to protect the child's interests, which may include obtaining necessary authorizations for release of information, review the child's social services, mental health, drug and alcohol, medical, law enforcement, education, and other records relevant to the case, reviewing the court files of the child and also his or her siblings, case-related records of the social service agency, and case-related records of other service providers. It's important to contact other attorneys for the parties and non-lawyer guardian ad litems, court-appointed special advocates or CASAs, and other service professionals to the extent permitted by the local rule for background information. Contacting and meeting with the child's parents, legal guardians, or caretakers with permissions of their attorneys if they are represented by counsel. Interview witnesses and individuals involved with the child, including school personnel, child welfare caseworkers, foster parents and other caretakers, neighbors, relatives, coaches, clergy, mental health professionals, physicians, law enforcement officers, and other potential witnesses. It's important to review relevant photographs, videos, or audio recordings and other evidence, documenting the results of these investigations, and monitoring compliance with court orders as appropriate, including the provision for an effectiveness of any court-ordered services. Minors' counsel should also investigate the interests of the child beyond the scope of the proceeding and reporting to the court other interests of the child that may need to be protected by the institution or other administrative or judicial proceedings. However, counsel is not responsible for instituting those proceedings or representing the child in them unless expressly appointed by the court for that purpose. And after learning of other existing administrative or judicial proceedings involving the child, communicating and cooperating with others to the extent necessary and appropriate to protect the child's interests. Minors' counsel should be aware of taking all other steps to represent the child adequately as appropriate to the case, including becoming knowledgeable in other areas affecting minors, which may include the Indian Child Welfare Act, information about local experts who can provide evaluation, consultation, and testimony, and also to consider other areas like delinquency, dependency, probate, family law, and other proceedings. Family Code Section 3150B states, upon entering an appearance on behalf of a child pursuant to this chapter, counsel shall continue to represent that child unless relieved by the court or upon substitution of counsel by the court for cause. Family Code Section 3151 goes into detail which discusses the responsibilities of minors' counsel, gathering, presenting evidence, expressing the child's wishes if that child desires to have those interests expressed, discussing the duties of minors' counsel, interviewing the child, and reviewing the court files. Family Code Section 31 basically is going over the same list of these responsibilities that was indicated in the California Rules of Court. Family Code Section 3151 also discusses serving notices and pleadings, that minors' counsel shall not be called as a witness, discussing the rights of minors' counsel as it did in the California Rules of Court, reasonable access to the child, standing to seek affirmative relief for the child, notice of any proceedings, and assert or waive privilege on behalf of the child, and psychological and or physical examinations. Family Code Section 3152 most importantly states that minors' counsel, upon notice motion to all parties and the local Child Protective Services Agency, may request the court to authorize the release of the relevant reports or files. It's important to note that these files will be held in camera review by the court to determine if they should be released to minors counsel. The court does not make any notice to the other party, and it does not constitute a waiver of confidentiality on behalf of the child. The relevant judicial counsel forms that you should look at are the FL 321 info sheet for attorney for a child in a family law proceeding, the FL 322 declaration of counsel for a child regarding qualifications, and the FL 323 order appointing counsel for a child. I've listed here additional statutes and code sections that you might be interested in, which include the Welfare and Institutions Code Section 827, Evidence Code Section 954, Evidence Code Section 765B, Evidence Code Section 3042, again, the California Rules of Court Section 5.250, and California Rules of Court Section 5.235, Probate Code Section 1470. There are relevant cases that exist regarding minors counsel, and I've listed them here. In Re David, 1984, 152 Calap 3D, 1189, discusses while counsel for child must consider the child's preferences, they need not follow them when they're not in the child's best interest. As a practice pointer, it's always wise to disclose to the court what the child's preferences are, and then also to discuss what you believe is in the child's best interest. The case of Carroll versus Superior Court, an attorney may not continue to represent multiple minors among whom there is an actual conflict of interest, and when an actual conflict arises, the attorney must be relieved from representation of any of the children. In Re Richard E., discusses when a child's interests are not protected by contesting parties, courts must appoint counsel for child. In Re Marriage of Metzger, the Court of Appeals in California determined that the appointment of minors counsel in a child's custody and visitation case does not violate the constitutional right of a parent to determine what is in the best interest of their minor child. The State Bar of California also had a formal opinion that stated attorneys representing parents in a custody dispute may not recommend the attorney be appointed for a child without consent of the client. There is an important note that this opinion was advisory only and did not bind the State Bar.